Welcome, everyone. I'm Teddy Downey, executive editor here at the Capitol Forum. Today, I'm very pleased to be joined by Professor John Newman of the University of Memphis Cecil Humphreys School of Law. John is the author of the recent paper, Lawless Antitrust. Many people must know that John worked at the was at the FTC leading a lot of what was tech policy, enforcement. So a lot of those lawsuits that are still ongoing, John was the brains behind a lot of those. And this paper, Lawless Antitrust, examines how modern antitrust doctrine has diverged from the statutory text and what that means for enforcement and competition policy. And before we get going, everyone in the audience, if you have a question, there is a questions panel in here. You can enter it in. We'll get to the questions later. Just put it in the Q&A or send us a text or email us at the Capitol Forum at editorial@thecapitolforum.com. We'll get to your questions. John, super interesting paper. I would love to know, like, why now this paper, for people who are looking at the economy, looking at this tech space, why does this resonate right now? What you wrote about here?
Yeah, well, first off, as always, good to see you, Teddy. Thanks for having me. Yeah, it is a somewhat curious choice of title and topic these days to write something about lawless antitrust, but have it mostly be about stuff that happened in the 70s and 80s, not the headlines that we're seeing right now. So maybe unpacking it, you'd really have to, I think, back up to 2021 when Lena gets appointed to head the FTC. I moved up from Miami to DC, joined her there, and among the other things we were looking at, but one of the things we were looking pretty hard at, of course, was the digital tech space. And, people have been pointing to all kinds of problems for a while. It felt like some of these companies, I'm thinking of like Meta in particular, just seemed like they were sleeping on their laurels. They weren't incredibly well managed. They were just these kind of monopolists that have gotten comfortable, which is not good, right? In America, we want people to be feeling competitive pressure to innovate, hire workers, build new products, and all that good stuff. So one of the ways we tried to get at this was to think about like what are all the legal tools we have, and then let's figure out which ones are appropriate for these markets, which have some different features maybe than we've seen before. So we did that. We kind of looked at like all the legal tools that are on the books, statutes that have been around for decades, case law that have been kind of mostly forgotten. And what we found was like there's actually some pretty powerful tools that seem to have some resonance for some of the problems that people were talking about today. I mean, I'm looking at things like exclusive dealing, things like vertical mergers, things like potential competition, like price discrimination. All of this has like deep resonance for the tech space. And all these are like laws and ideas that had been floating around since the 1930s, if not before. And we started seeing a lot of old wisdom in these old cases. I mean, these are judges in like 1950 talking about how competition is a stimulant and monopoly is a narcotic for business. I'm like, yes, that's what we're seeing right now. So this felt great. We were all really excited. But as we started digging deeper and connecting like 1960 to now, we realized there's a big mess right in the middle of it that was going to prevent us, make it hard for us to use these tools. And that was not by accident. And that really is kind of the seed of this paper is to describe once we turned over the rocks and kicked over the logs, the bugs and maggots and things that we found underneath that had been left there by our predecessors.
Yeah, I think a lot of people, just sort of in the world think, oh, judicial activism, they think that has been thrown at uh, Democrats over the years, Democratic judges who are trying to push ahead with, more aggressive enforcement, of environmental rules or what have you, right? And sort of they're always being accused of legislating. But and that kind of connotes a doing something more, like adding something.
Hmm.
What you point out in your piece is judges that sort of cut off huge swaths of law with these decisions or otherwise constrain the law. I'd love to just, walk through some of the highlights in the paper. I know Judge Posner uh, starts off the paper. He appears a couple of times. walk us through some of the highlights here of examples where, judges, judicial decisions or have really curtailed antitrust law.
Yeah, and that's such a good insight, Teddy, that I think it's easier to get away with stuff when you're doing negative things rather than doing positive things. I think that's basically what happened here. One initial point I think is worth keeping in mind is it wasn't just judges, it was the agencies too, and in particular the FTC. I actually view that as maybe even more problematic, but let's come back to that. I do think the Judge Posner example is probably like the banger of the article. It's pretty wild stuff. So, okay. Richard Posner, Chicago School antitrust guy, gets appointed by President Reagan to the Seventh Circuit Federal Appellate Bench. And among other things, he heard a decision involving Clayton Act Section 3, which is one of those statutes that people just kind of forgot about for a while. I don't know of a single law school class that like would teach Clayton Act Section 3, at least before recent events. It was just kind of one of those lost antitrust statutes I was talking about. Well, how did it get lost? Okay, Posner got himself a section Clayton Act Section 3 case called Roland Machinery when he was on the Seventh Circuit. And for folks who don't know the history of the Sherman and Clayton Acts, basically you've got Sherman Act of 1890, pretty broad, pretty general. A few years go by, Supreme Court cabins it pretty strictly, and so Congress passes a new law, the Clayton Act, that's much more clear, much more specific, and it's much more aggressive. It's just the language is different, the thresholds are different. It's targeting specifically, among other things, exclusive dealing. Okay, and that's what this case is all about. So you have these two very, very different statutes. One passed directly to override the Supreme Court's treatment of the other. Posner, with just kind of a little bit of throat clearing, just kind of comes out and says, "Yeah, these are different statutes." And the Supreme Court, my ostensible bosses, have said as much, and they have applied different standards. They have said it's easier to prove violation under the second one. But I'm not going to do that. He just said, I think the rule of reason should apply, which is the old Supreme Court test that Congress specifically overrode with this new law. His citations are like laughable for that proposition. He cites like a concurring opinion, an out of circuit like district court opinion. It's just kind of unbelievable, and I think the way he got away with it was because he was walking back rather than walking forward, as you said. Okay, that's one decision. Well, it's been cited over 1,000 times by subsequent decisions. Like, it's a big one. And lo and behold, the federal agencies still have not brought a standalone Clayton Act Section 3 case ever since then.
And it's not just the thousand citations. And I can see why, if you don't want to be on the wrong side of this law, you would cite it. But it's also like that it was so successful. Like there was no one standing up, no one saying this was wrong, no one taking him on, just that you can get away with it with total impunity. And like somehow he's still a respected judge, right? Like a lot of people think he's a smart guy, what have you. Obviously there's been criticism from the anti-monopoly movement about what he's done. And he showed up at one of those and basically said, well, there is no antitrust law anymore.
Yeah, he
Right?
killed it, right?
Yeah, I killed that, right?
Yeah.
Fun fact, my college roommate clerked for him and now works for OpenAI. Shout out Tom Gorman. But the other thing you mentioned is Arita Hovenkamp teaches this, right? Like, so it's so ingrained in learning that no one even knows that it might as well not exist anymore.
That's it. When you're talking about activist judges, isn't a single judge with a stroke of a pen repealing a congressional, like a democratically enacted statute? I mean, that's beyond activism. To me, that's the kind of thing that gave me this title. That's lawless, I think. You're not using the statutory text, you're not using the history, you're not looking at the purpose, you're not comparing it to other laws, you're disregarding the Supreme Court. Like, what are you doing? So usually one check on that is scholarly criticism. You're not supposed to get to go on fancy speaking tours and get the adoration of a bunch of prestigious law professors when you do that sort of thing. And yet, as you point out, the leading scholarly treatise just takes this approach. It says, yeah, pretty much just the rule of reason for all kinds of vertical restraints. Doesn't matter what underlying law we're using. And that, to me is a kind of a failure of the academy. That's just not what we're supposed to be doing as law professors. There are econ departments that would look at this differently. There's business departments that would look at this differently. Of course. we're supposed to be legal academics, right? And I just think it's inappropriate.
And so let's say he hadn't been able to do that. What would, if this tool were used, could be used, how would that make bringing cases easier? Like what kind of cases would we be seeing more of?
Well, a couple different things. One, there's a FTC case involving some de facto exclusivity in inputs, pesticides for farmers. Uh, it's still going on. One of the few that's still going on, and the allegations are that the defendants have like monopoly level market shares. In my view, we should be seeing cases well before we get to that point. So that's one thing that a revitalized Clayton Act Section 3 could do. I mean, I think that's what it was supposed to do, right? Instead of waiting until you've got 70% of a market locked up, it's supposed to be kicking in when you've got 25% and you're threatening to get 30, frankly. So that's one thing. Now that's still dealing with like physical goods. We started out talking a little bit about um, me pondering tech problems as the source of all this. Well, there's some old case law that says, and this statute was also meant to apply to things, even if they are intangible, if they are kind of like a mass-produced good. So, I'm thinking about some of the like Google exclusive dealing contracts. Same thing, maybe. If you could stretch the statute just a bit to cover this intangible new product, we should have been bringing cases well before Google had 90% of a market, right? Back when they had 30%. I mean, that just yields such a different world than the one we live in, I think.
And and so as a result, basically, because this doesn't exist, antitrust enforcers are constantly having to package everything into monopolization cases, and you have to wait until they already have a monopoly, and so that ends up basically making life not completely impossible, but really, really hard, right?
I think that's a big part of it. One, it's you have to wait until the power threshold gets so high. There's a time element to that. If you wait that long, now it just becomes, oh, the way the world works. I guess Google just is the only search engine we have, right? It lets the monopoly normalize itself. I think that's a problem in a litigation setting. And then two, this Clayton Act standard, like the one we apply to mergers, it also interjects like a probabilistic analysis. Sherman Act kind of requires you to be pretty sure that the company's monopolizing the market. The Clayton Act just says may. It's like it's illegal if this may cause a problem. That's at least ostensibly a much easier analysis for your plaintiffs. I mean, the other nail in the coffin of all this too then was, hey, well, this is just a federal judiciary. Paper points out the FTC did the exact same thing in a case that kind of went under the radar. So this whole world that I'm talking about, it was pretty well buttoned up by the Chicago school.
And when was the last time, I think you mentioned in this a paper that an agency brought a standalone Section 3 case? It's
As far as I know, it's the In re Beltone case that went before the FTC. It was started under Carter, then resolved under the Reagan administration in a very similar fashion. They just said, we'll treat it like the Sherman Act.
Yeah, so it's been like 40 years.
40 plus
Um,
years.
can you walk us through some of the other examples you have in the paper of the, antitrust law becoming illegal?
Yeah. So there's a few other sort of positive or like actual moves that were done. There's also some non-enforcement moves that were done we could talk about. But one of my kind of my simultaneous favorites, in as much as it's so ridiculous, and least favorites because it was so annoying when I was at the agency, was this concurring opinion that Commissioner Wilson in 2022, I think it was, wrote in the Illumina Grail vertical merger case. So we're talking about tech. It was a platform vertical merger, right? Involving like a nascent market, really, really interesting case and like life-saving technology at stake. Commission, here's the appeal from the ALJ. Commission issues an opinion that says, hey, we applied the Supreme Court's test for a vertical. It's been laid down, it's on the books, it's been applied by dozens of other courts. Um, we applied that, and we applied this newer ability incentive framework that the agency's kind of developed. Um, Either way, we think the merger is illegal. Kirsten Wilson weighs in as a concurring opinion, not joining the majority, um, to say, yeah, there is no Supreme Court test for vertical merger legality, which is interesting. Like, that's an interesting claim. Um, and was kind of striking to me because this is a Supreme Court case she admits has never been overturned. Okay, so how is it that there's no test in modern antitrust, as she was saying? Well, she lays out a few arguments. She says, "Oh, we the agencies issued some guidelines that didn't include that test." I'm like, okay, as far as I know, agency guidelines cannot overturn the Supreme Court. She said, "Well, there's really hasn't been any cases recently that use it," which wasn't true. There was one in 2016, and then she said, "And academics don't like it." Like, man, I'm an academic. I would love to have the power to reverse Supreme Court decisions I don't like, but we just don't. You're just behaving lawlessly. You're saying here's the law and I don't like it, basically.
Yeah, it's a challenging thing. I mean, it puts you in a really tough bind if you hold yourself to operating within the law, and you can lose either within the, way the law works, or you can also lose in this other option, which is just completely outside the law. And so I think that does go to why it's not why it's so hard to win these cases. You're always going to be at a disadvantage if you can have the real merits or made up doctrine. I want to take a step back here because how much do you think this, I can't remember the exact language you used, but it's just sort of the aura of a legal antitrust, just this sort of that the aura of it being illegal in this specific area of law. Like, where do you think that that comes from? Is it because obviously anti-monopoly movement talks a lot about the antitrust paradox and Bork. And you've got Supreme Court precedent that's citing a book, right, as opposed to statute sometimes. Where do you think, all of this idea of, well, I can just be a judge and just wash it away because people don't like it, uh, comes from?
Yeah, I think it's an ideological move, right? It's a justification that was put forward for it. But I think it's an ideological move by some people who were looking at statutes and case law that they did not like, but they knew they were not nearly popular enough to actually go before Congress and get the law changed. And so instead of engaging in democracy, they engaged in a kind of ideological takeover project. Now, part of that was putting together an intellectual framework, speaking somewhat generously, to justify what they were about to do. The way they did it was to say, okay, we we want to roll back the clock to before 1914 and these new laws came on the books. We want judges to be able to do that. We know Congress won't do it. So we need judges to have the sort of authority to do it, which is kind of a stretch, right? So their argument was then, oh, the antitrust laws are so vague and empty that they were just a total, quote, blank check to judges to do whatever they want, come up with root to branch, right? Like top to stern or stem, whatever the saying is. Like from the goals all the way at the top down to like the application in a given case, judges can just make it up. That was their argument. And then they kind of tried to throw a few more things at the wall to see if anything else would stick, but that was it, basically. That freed them up to say, oh, instead of the law, we can just follow what our favorite economists say, and that is doing law. My argument in the paper is to say, like, no, it's really not. Like, it's got the kind of cloak of authority, but it is lawless. It kind of in an insidious way undercuts the rule of law itself. If you're just removing the role of law, it's kind of a clever little line in the paper, I think. But if you remove the role of law, you have no rule of law left, right? It's ruled by power, by fiat.
Yeah, and like you said, we do see that a lot now. Obviously, your paper is looking at historically. We see that all the time now. Do we have a king or you know bribery law? I mean, you just name your Voting Rights Act. I mean, you just name your issue. This is definitely spread. It's less unique now, and it's a legal. Under the illegal nature of what's going on, but. I want to get back to, implications in a second, but any other examples? Yeah, let's go through a few more examples because you have a lot in there and they're all really interesting and just like how the event happened.
Yeah. Here's another one that's kind of a favorite slash least favorite because it was so fascinating, interesting. Nobody had talked about it as far as I know, but also was like a huge thorn in our side while we were at the agency. And this is the In re BAT merger case that went before the commission in the 1980s. Um, we uncovered it when we were trying to block Meta from buying Within, this VR app. And our theory was potential competition, that Meta would build its own app if it couldn't just buy every app out there. Not the first time somebody thought of that theory. There were cases back in the day, including Supreme Court cases. Uh, the commission had started a case in the 70s using this theory. And then the Reagan era people came in. Now they had a choice. They didn't like the theory at all. They could just dismiss the case. That would be one tack. Instead, to their credit, they're pretty savvy. They said, "Well, no, we're going to hear the case, and that gives us a chance to make the law, basically, as commissioners." And that's exactly what they did. The Supreme Court had said, "There's no unique test here. Here's the standard. You treat this basically like other merger theories. Yeah, you have to prove your case, but we're not going to apply some like weird one-off standard to this type of theory." The commission, citing basically no authority other than an academic article again, said, no, actually, you need clear proof that the buyer, this would have been Meta, would have definitely entered the market if it couldn't acquire the target. Okay, that's an evidentiary standard that appears nowhere else in antitrust law. They just made it up based on this academic article. And saying you have to prove that Meta, our case, would have entered. You've made a statute that should be probabilistic. The language says may, and you've turned it. You've taken your little pen and you've crossed that out and overwritten what Congress said. It said shall, right, or will. So they basically changed the law. What makes that, I think, especially pernicious is nobody's going to appeal it. The defendants are super happy when they get a commission opinion for them, so they're not going to appeal. The commission can't appeal itself. So you have no check whatsoever on these agency heads writing law, right? Changing the law. And that's a problem. We ultimately overcome it in the Meta Within briefing. If you look back, the judge did not adopt that, but you're spending capital, right? Every time you try to get a judge to go along with something, you have to spend some capital. So it was a real problem. That I think is a pretty bad one. There's non-enforcement. The agencies just stopped enforcing like laws against price discrimination or interlocking corporate directorates. Congress never said to stop. They just said we don't like it anymore. And then maybe one last one. Even worse, it wasn't that they just stopped enforcing laws against price discrimination, which maybe you're just trying to save agency resources. Yeah, you're just allocating. Sure. Except they were actually spending agency resources to try to like overturn the law or like weigh in for defendants as amicus in briefing. So it wasn't that they just were saving resources. They were spending resources just trying to change the law, which again, I just view as like not an appropriate exercise of agency discretion.
One thing that comes up a couple of times is changing the level of proof. You mentioned going to clear proof when it was some kind of probabilistic thing. You mentioned in the paper a merger where the judge changed maybe to would be likely to. My experience talking to people at the FTC is that they tend to use likely. Like they don't even really think of it as may, which is just kind of like, gets your point about how entrenched this kind of stuff gets in the educational process. Um, that seems like a pretty hard thing. That seems like a pretty dramatic change when if you're supposed to be only, needing to prove with a 30-40% or even potentially lower may. I mean, what percentage are we really talking about? And you're having to all of a sudden prove that it's likely or certain, obviously that seems very effective. Are those actually, but I've seen the FTC and DOJ bring cases where they're actually going back to the statute and saying, hey, this statute is actually may. So Is that the type of thing that, you know, is as easy to just wish away, or how effective have all these changes been in sort of making it harder? I mean, obviously you can point to the case law, but the statute is still there.
Yeah. Yeah, it's a good question, a tough question. I mean, it's if you look at the briefing that went out under the agencies from say 2021 to 2024, it is pretty clear that we were trying to hammer on this stuff. It's let's go back to the text of the statute. We've gotten way off course. I would say with mixed success at best. I mean, there's a few opinions that I think do a pretty nice job here um, on this kind of thing. But by and large, it just seems to be maybe so entrenched in the law that these judges are looking at, the case decisions. There's always an incentive as the enforcers, right, the actual litigators, to overplead a little bit. And it's tough to tell your people to go out and say, here, just set the bar here, and if you don't persuade the judge, you lose. They want to say, well, maybe you're right, the bar is here, but we want to prove to the judge that we're here, right? So they're always incentivized to say, no, judge, I mean, this thing will harm competition. We're way past the statute. Kind of inadvertently, maybe allowing that slippage to occur. I think that's one other problem that goes on with the FTC specifically is when they march into federal court to get a preliminary injunction, it's supposed to be a probability of proving a probability in their own in-house court. I just don't think the human brain is like set up very well to do that kind of thing. And there's some pretty good psychological research on that. But properly speaking, if the actual statute only requires like let's just say a 30% chance, in federal court, if the FTC could prove like a 50% chance of a 30% chance, they should be getting the injunction. And that is not what it felt like to me. It felt like we were doing a trial, like beyond a reasonable doubt every time. But it should have been like, man, if there's a 15% chance, this thing should be blocked. That's pretty potent laws. You can see why they were a real target.
And so you've done this historical analysis. Where does that leave us now? And you know, obviously you did this historical analysis, and then you've had this recent activity from the second Trump administration. How are you feeling about because where the law is going? Because in some ways, actually, you've had the anti-monopoly movement has had some recent success. Obviously, Ticketmaster, Live Nation, jury trial unanimously decides against Live Nation. Judge in Nexstar Tegna sides with the states, blocks that deal. So in some ways, the groundwork that you all laid is actually creating some room for success. Obviously, you can look at other examples of things not going so well. But how are you thinking about the current moment
Mm.
in light of writing this paper, what you see going forward?
Well, maybe a couple thoughts on that. One, and this harkens back to something you said earlier, Teddy, that I am kind of advocating for us to fight with one hand tied behind our back. If the other side is willing to totally opportunistically pick the law if they want to, or just disregard it if they don't, they do have a bigger option set than a side that's willing to actually follow the law. It takes some options off the table. And I'm pretty keenly aware of that. It is the sort of thing that keeps an academic up at night, and who knows if anybody ever reads these papers, at least you do, Teddy, so thank you for that. But to the extent they do, you want to get it right. You want to have the right strategic calls. And I think it is the right strategic call. I think if you just run rampant, right? If you just do lawless antitrust, as I've described it, eventually you lose any kind of credibility. And that's what we need, right? We need popular underpinnings like the stuff that's driving Live Nation forward, like the stuff that's driving Nexstar forward. If this is going to have any kind of lasting impact, I think it's got to have a kind of legitimate, we are doing the law as the people put it on the books, cloak or mantle around it if it's going to work. So I do think it's the right methodological move to make at this moment, but I also think there's just a lot of institution building that still needs to happen frankly, among the anti-monopoly, if it's even a movement, right? I mean, it's kind of a project at this point, and I see people sometimes out in the streets. There was a protest around the Paramount Warner Brother or Paramount potential acquisition the other day. But that's where we, I think, need to get to. And that tells me there's still some institution building that needs to happen among, labor unions. You've been so good at this study by just convening, like bringing people together, getting them in the same room. I still remember, I think your conference was the first one where Lena and Jonathan spoke at the same conference back in like 2016. That, I think we need more of that, frankly. So that there's a much thicker, like more robust network and maybe an actual movement underlying it.
Um, got a question here. I've thought often about arguments like Professor Newman's in the context of the failing firm and weakened competitor defenses. The failing firm defense was considered and ultimately not included in the CK amendments, yet Supreme Court continued to recognize it. Eventually, we got the WC defense, and now practically every merger, it seems like, includes a quasi WC defense, see Novant. But I do struggle with what courts in a PI posture are supposed to do, i.e., should the equitable posture of most agency challenges to mergers give courts more leeway to consider defenses like these? See also efficiencies. Isn't there an argument that a court considering a PI is more a chancery court than a law court?
Hmm. It's a really good question. And yeah, as we've seen failing firm kind of start to morph into weakened competitor, at some point, that just starts to become, we want to do this deal because we think it'll make us more powerful together, right? Like that's kind of the core of that argument. Once you start to get to like weakened competitor, I think. Yeah, I mean, to some extent, it is correct that you are asking for equitable relief in one of these injunctive hearings. Um, that being said, I do think there's a very clear difference between the FTC and a normal plaintiff in one of these injunctive hearings. And that is that the FTC Act, Congress specifically passed to make it, they said, I mean, paraphrasing just a bit, very, very easy for the FTC to get an injunction, right, to stop one of these mergers. I think the actual quote was to make it so that this was liberally available to the agency. So yes, I think it is to some extent a like what's good for the public analysis. That's one of the factors. But I'd say with a pretty heavy thumb on the scales, if you just actually look at the law itself in favor of granting the um, injunction. And the underlying idea, once we're into talking about just what's in the public interest, I think is that in Congress's view, historically at least, firms were just really not supposed to be defaulting to mergers and acquisitions whenever something went wrong or whenever they wanted to build out a new business unit. And we've kind of gotten into that world for some of these companies, but Congress had a vision where you're supposed to be trying your damnedest to roll up your sleeves and grow internally, like build a better mousetrap. Right? That's the default. So all to say, it's a great question. I think the premise is right, but I think the law actually does favor it pretty heavily.
One thing, I've got a couple of other questions here. We're going to get to them. You mentioned Congress. You know, what's their role? Because I can't think of a way to hold judges accountable other than for Congress to say, you're not enforcing the law that we wrote. If they're not willing to get up and say, hey, you have to follow the law, you know, I'll tell you, from my perspective, I've flirted for years and years and years. How do I assess a judge's opinions and decisions? And I think what you're describing makes it's impossible because how do I, it's like really hard to figure out when they're following the law or when they're making it up. I mean, obviously you did a great job in your paper, but it's really hard to keep track of them and what's going on and what their ideology is and because, you know, they may not know. Some judge may be just looking at Hovenkamp text and just doing what's in there. They're not necessarily ideologically aligned. They're just kind of like, I'm looking at some of this precedent that they don't really know is made up. There was no stink made when it happened. It's got 1,000 other citations. The only thing they were going to find is your paper to know that it was completely, fabricated. So what is Congress the answer? What's the answer in terms of
Mhm.
like holding judges more accountable? Like do you have any sense of like how they think about themselves, what have you?
You know, yeah, it is a tough question, in part because I think at the root of a lot of this really is just a kind of a, for lack of a better word, a kind of a neoliberal worldview that I think a lot of the kind of people who have been appointed as judges in the past 30, 40 years have. And they don't even necessarily seem to know sometimes. They don't seem to be conscious of it. And I think of that when I read the US v. Google search remedies opinion. I'm just not even sure reading that Judge Mehta is aware that he's taken a gamble based on his assumption that the market will fix all the problems. Right? He like gets close to saying that, but I'm just not sure he realizes the stakes of what he's doing. He thinks he's doing the safe thing and avoiding the gamble of a big remedy. I'm like, no, brother, like, you're gambling either way. You don't know the future, so you can either follow what the Supreme Court said, which he did not, or you can kind of default to doing nothing, which he did basically did. Um, okay, so that I think is at the root of a lot of this. How do you fix that? Whew, that's a big, big, big problem. I think it starts though with training. When all these judges go to law school, we're starting to see some professors in some pretty fancy schools who are probably teaching antitrust different than it used to be taught, which I think is a good thing. I think Lena is putting together the center up at Columbia to train law students who are going to go out and become litigators, become judges. I think that's phenomenal. I think that's great. Judicial training might be part of it. And then I do think Congress, especially holding just kind of like spotlight hearings, can be helpful. I think academics, not just, you know, accepting that the world is the way it is and we should just argue over little things here and there and stepping back the way this paper tries to do, I think is part of it. But it is a big problem, so it's going to take a big solution.
Got another question here. In addition to rogue judges, we're also dealing with federal enforcers who are ambivalent about enforcing the law or even accepting bribes to let mergers through. You said it, not me. Any thoughts on making private enforcement more robust, especially in the merger space?
Yeah. Murder space is tough, as we know. Like historically, private enforcement hasn't been super strong there on the ex ante side of things, right? Because blocking a merger doesn't yield much of a payout. And it's tough to justify spending a bunch of time and money if you're not going to get a damages award at the end of it. Couple thoughts. One, this is just kind of naturally happening. There are a bunch of really, really super sharp, super motivated law students who are very interested in antitrust in a way that was not true 10 years ago. I've said this anecdote before. The first time I taught antitrust, I had 3 students enroll. The last time I taught antitrust, this was down at University of Miami. It's a big school, but I had 140 students in that
Wow.
class. Like that is a sea change, right? And I've talked to other people who are that way. Lena's class at Columbia, huge. Herb's said his class at UPenn has gotten huge. So there's a bunch of really, really sharp, super motivated people who are about to become attorneys. A lot of them would have gone to the federal agencies in the past. They are by and large not going there. They're savvy enough to know that's just not the place to be if you want to do good, interesting work. They are flooding into cool, nimble, new, some older, but some new plaintiffs firms. So there just is like an army of people looking at this problem that didn't used to be there, what I think is great. And then we can start thinking creatively about like nonprofit models, litigation funding models. There are some things percolating up, I'd say, like watch this space.
One thing you mentioned in the paper that's been, you know, a area of law that's been curtailed is Robinson-Patman Act. We actually have seen not just that big FTC case that's still ongoing, the liquor market case, but we've also seen a lot of firms and groups really leaning into that Robinson-Patman. You've seen so much activity on price discrimination, the documents coming out of that Pepsi relationship with Walmart, just explosive, insight into how this type of arrangement can actually increase prices, which is at odds with the sort of long-standing view that that you're stopping Walmart from lowering prices kind of mantra. How big of a deal that seems like one area that's kind of overcome this setback that you mentioned in the paper. Uh, why do you think that is? How do you think that that law has had a comeback despite kind of being at the centerpiece of like judges and FTC trying to make it just disappear?
Part of it is the private bar, who kind of kept it on life support, I would say, during the lean years. There weren't a ton of cases, but with the cases there were brought by private plaintiffs, and they continue to have some success. My sense is, and this is based in part on talking to a few of those private lawyers who've brought and won these cases. It's like when you get the kind of case that you could satisfy the statute with, the facts are actually pretty strong and pretty compelling, even to a layperson. That Southern Glazers case you mentioned, I think, is a pretty good one. I thought the Pepsi case was a pretty good one as well. When you start explaining, like, hey, a seller probably wouldn't just grant a discount out of the goodness of its heart. Why would it? It probably means if it's treating one buyer differently, it's not based on a cost difference. It probably means that buyer's throwing its weight around. The seller's going along, and they're, in economics terms, kind of creating this like two-layer barrier to entry that chokes out rivals downstream. We favored partners get to split the resulting above market profits or above competitive profits. It's a nice little cozy arrangement. So I think that's part of it is private plaintiffs kept it on life support. The Supreme Court hasn't destroyed it the way they've destroyed a few other areas. Their last decision wasn't too bad on it. And I think that's just kind of happenstance, honestly. Um, and then the last point is the other side was pretty lazy. They never actually did the economic groundwork to really cement a position. Maybe because he couldn't do it because they were wrong. There's been some empirical work recently that says, yeah, no, actually, this does have it can have the effect of stifling competition, and then prices go up. Even if you think in the short run you're losing discounts, what in the long run you're getting a less competitive market. We know what that does.
Got a few other questions here, so let's get to them. Are consent orders even legal? You can keep doing anti-competitive stuff, but here is a court/DOJ blessing. Are there any are there any consent orders you have liked that worked that protected competition? Don't parties just wait out the order?
Yeah, I'm pretty skeptical of consent orders in general. I mean, there's situations where, like, let's say I'm just, talking strategically here, because these agencies are litigators, right? The FTC has a real, like, regulatory authority as well, but it is also a litigating entity sometimes. There's times when issue a complaint, you file a complaint based on what you thought were the facts. You get into discovery, the facts just don't pan out the way you thought. The world changes, a new witness pops up, whatever. The world can change such that you're just not in as strong a position as you thought. Going into a trial may not be the optimal strategy for the American public, right? So I will grant that there are just situations where a consent order is the best of a bad option set. That said, I'm pretty skeptical of them in general. A few that have emanated recently, I would be very skeptical of. I think when it comes to like partial structural divestitures for mergers, there's a really bad track record. But the one that I love is, of course, the 1956 AT&T settlement, where the government said, "Yeah, you've been doing some bad stuff. License all your patents royalty free." Like, that's if you'll pardon my language, like that's a fucking consent order, bro. And some economists have looked at that and said it actually had a more positive effect on the U.S. economy than the Marshall Plan. Like, it was an unbelievable wave of innovation and competition that was unleashed by prying these patents out of this monopolist's hands. That was a consent decree.
I do wonder what your thinking is, because when I look at these companies, Google, for example, is just so big and so dominant, has so many monopolies. I mean, you're not just talking about search, you're not talking about ad tech. You're talking like they're monopolistic, or oligopolistic in AI at this point. You gotta think that just based on all the data that they get, you've you've got Waymo, you've got Gmail, you've got YouTube, you've got YouTube. Hollywood's worried about YouTube. Uber and Lyft are afraid of Waymo. Um, we could probably spend half a day talking about Google. I don't even know if you could have enough antitrust cases brought at once that would matter to their power. Their spending power is bigger. Their capex spending is now like bigger than c most countries, right? Like they make their own, they design their own chips now, right? You know, Amazon's the same way. They want to enter a market, the stocks in that market go down, right? Um, some of these companies are just so big. Have we moved past the point where and any antitrust enforcement is really going to have an impact? And do you need a law to change? I mean, some of these, you know, if you have to wait until they're a monopoly to do exclusive dealing cases, right? Like and lump them in a monopolization, it's too late at that point, right? I mean, they're going to get around it. They're going to fight you. They're going to use their political power. What do you know, you look at these cases, obviously you must still be watching them and be interested in them, but are you at the point where you're like, hey, we're just going to need so much more to actually challenge to disintermediate this concentrated power? Or do you think, you know what, we just need more cases and we can get there?
I would say backing up from, let's start with remedies. If
Yeah.
we're not going to get stronger remedies than we got in search, all the cases in the world, I don't think are going to do much to move the needle. I mean, yeah, on the margin, is the world better if some of these, say, reciprocal dealing cases brought by publishers against Google succeed and we can terminate that conduct? Yeah, but the publishers are still going to be totally dependent on Google for any web traffic, and Google's going to have its other hand around their throat using AI overviews to like replace them altogether. There's not going to be much they can do about it. So I'm kind of simultaneously like optimistic in the sense that when you look back at history, people thought AT&T was undislodgeable, right? At one point, it was doing everything from handsets to fill in the blank. Um, and its spending was pretty unbelievable. I mean, on par with governments as well. And eventually it was broken up. Now there was a longer history there of keep kind of trying to keep it in its lane that we have totally failed at with Google, candidly. Um, so there's something to build on that we don't have. But all that's to say, I'm a little bit optimistic because historically this has worked before. I'm a little bit pessimistic based on some of the early results when it comes to remedies, because the way that it worked before was big, sweeping remedies by confident, bold judges that were willing to kind of unleash or unlock these markets.
So how big a deal do you think the ad tech and the Live Nation remedy decisions are in terms of changing that dynamic potentially or underscoring it?
High stakes, right? I think if we're going to get a structural remedy against Google, it was always going to be ad tech. So this is the one. And same for Live Nation. I mean, it's in some ways I'm more optimistic about that than I was at the start. Now that DOJ did their kind of weird rushed 13th hour settlement, to me that kind of sets a floor. This judge seemed like he might have just done that after this liability finding, but that set a floor, I think. So I think the judge is going to have to go further. And my hope would be if he doesn't, you've got a bunch of states that are now like ride or die on this. They could bring their own cases in their own state courts. Some of them have some pretty wild statutes on the books they might unleash. So I think to your question, yeah, those are two pretty high stakes cases. And I'm at least cautiously optimistic on both.
We got some more questions. Let's get to these before we run out of time. Here's one guess. My experience is that we are stuck between two defense arguments about judicial restraint. On the one hand, judges should not get involved in second guessing business decisions or micromanage company conduct. But on the other hand, black line rules like the per se rule ignore practical business realities.
Yeah, I think that's tough. And I'll be the first to say I'm not sure that going back to the per se rules that were more prevalent in the 50s and 60s is my preferred solution to all this. But if you go back and look at those cases, even when they were saying per se, oftentimes judges would sort of find a way around it, tweak a fact here and there, and end up doing what they wanted. So to my mind, I guess the bigger project is not so much like the final form of the rule, but trying to destabilize that first assumption that the guest points out correctly,
Which is like
right?
what you pointed out about neoliberal judges. Basically, they're just like, let the market forces decide, which is like a funny mystical way of doing. law, but
Yeah. No, I think that's right. And you can do it without saying business people are like stupid or evil, because you're not just trying to convince a judge that markets don't necessarily work. You're trying to convince them that business judgment isn't a magic, always good thing.
or yeah,
So,
they shouldn't get deferential treatment, which by the way, in the jury trial in Live Nation, they didn't get, right? You could look at that jury trial versus most judicial trials. And if that had been a judge, I would have actually been nervous that Live Nation could have won, right? I would have thought,
yeah.
well, not Live Nation could easily win. They got these charismatic people up there. Oh no, that was taken out of context when we said they were suckers and we were gonna bleed them dry. That's this one guy. Yeah, he still works there. He didn't get fired, but we don't like him. We say that was so
Yeah.
naughty.
Yeah.
I could see a judge. Oh, yeah, this is a successful business person that, maybe I saw at the country club or whatever, right? Like whereas the jury was just having none of it, right? So
Yeah.
I get what this guest is saying, but I think the other side of it is black lines rules like the per se rule ignore practical business realities. I mean, I think at the end of the day, businesses adjust to the law. If the law is
Mhm.
made, it's made for moral reasons as well as market reasons. There's no like excusing away a per se law. It's there for a reason. Someone came up and said we should do it this way. And business people can figure it out. I think it's yeah, they ignore some things, but they make it easier on everyone. They actually make it easier on a lot of businesses because it's like clear what's legal and what's not legal, so they can adjust. So I think you
Yeah.
can look at both those points, both in different ways. Couple more questions here. You touched briefly on the agency resource limitation, just looking at mergers. It's a huge amount of resources to staff a second request, let alone litigation. Conduct cases are even worse given the length of the investigation and litigation. What can our agencies honestly do to address this? Are state AGs able to help fill in the gap?
Yes. Um, I I do think at times in the past, the agencies very occasionally staffed things a little more aggressively than they may have needed to. But there is a minimum floor, and that minimum floor is still pretty high, below which you just cannot go and litigate one of these cases. So it is a practical reality. I think one, we've got to attack the law where we can to make the burden easier. Um, I think two, there can sometimes be a tendency to want to get everything perfect at the agencies because it's kind of a heavy burden to represent the American people. And so I think sometimes injecting some fresh blood from, say, the private plaintiffs bar, from state AGs, which is something we tried to do pretty consciously while we were there. Let's not only hire people from big law firms that have infinite resources. Let's hire some people from these places that don't have infinite resources and have kind of learned to deal with it. So I think a little bit of like mixing some fresh blood in, injecting some new ideas, but also, we've got to change some of these legal standards.
Last question here. When is someone going after Walmart on private label? Government agency, not private litigants. I'm guessing they must be talking about state AGs because it's certainly going to be at least 3 years before anyone would reasonably investigate Walmart. Uh, but what do you think state AG appetite is to, look at, dominant supermarkets and their private label businesses?
Hard to say if you've got evidence that it's causing food prices to be higher than they would otherwise. I think the appetite could get real high real quick among state AGs who are, if nothing else, pretty well attuned to what their voters care about. And right now, voters care a lot about food prices. So if the facts are there, I mean, I think you've got a bunch of state AGs who would jump at the chance and are probably feeling pretty good right now coming off of a couple big wins you referenced earlier.
Yeah, would it be what kind of case would you bring? I guess that's the real question. Because,
Yeah.
the whole Walmart with um the brands is it makes it a good Robinson Patman case. But then you've got the private label and it's they
Yeah.
own it. It's vertical. It's like like as obvious that there's an exchange there. I mean, I guess
Yeah.
someone's making the private label, so could it be the same type of case ostensibly?
maybe some kind of maybe if Walmart's demanding exclusivity from the few private label manufacturers in a given area. I don't know. Yeah, it's a good question. Maybe one to unleash your
Yeah,
army
yeah,
of
yeah, man.
reporters
Put
on.
someone on that. That's something to look into. Well, John, as always, a pleasure. Uh, I found the paper really, really fascinating. The whole the Fordham, that whole group of papers, we're gonna try to get as many of those people to come on and talk about those papers. I thought they were super interesting. Good luck with everything. You got an uphill climb, certainly, but look forward to hopefully seeing you soon at one of these the upcoming antitrust events.
All right, sounds good. Good to see you as always, Teddy.
And thanks to everyone for joining us. This concludes the call. Bye bye.